Hello viewers, Namaskar. I am Professor Bhageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on the new criminal laws. In today's session, we will deal with the changes that have been brought about by the new criminal laws in the chapter in our Bharatiya Nyaya Sanhita titled Offences against the State. So, chapter 7 of Bharatiya Nyaya Sanhita, which was earlier chapter 6 under the Indian Penal Code, is titled Offences against the State. And there is one very significant change that has been introduced, and that is that the old section 124A, which was titled sedition, that has been removed now. So, Bharatiya Nyaya Sanhita has omitted section 124A of Indian Penal Code, under which sedition was a punishable offence. In order to expel the British from the country, thousands of our freedom fighters spent the golden years of their lives in jail on charges of sedition. By the PIB, that is Press Release Bureau, notification dated 20th December 2023, it was stated that abolition of this offence in independent India will give satisfaction to the souls of thousands of our freedom fighters who spent the golden years of their lives in jail because they were charged with the offence of sedition. So, now a new offence relating to act of endangering sovereignty, unity and integrity of India has been added in place of that old draconian, archaic and colonial provision section 124A of the IPC, and now instead of that we have section 152 in the Bharatiya Nyaya Sanhita 2023. There was a judgment of the Supreme Court in the year 2022, S.G. Wombat-Kerr versus Union of India. Now what happened in this case? A retired army general, S.G. Wombat-Kerr, he had challenged section 124A of the IPC as being violative of freedom of speech that is guaranteed to all of us under our constitution. The Supreme Court of India, while evaluating the constitutional validity of this provision, acknowledged the potential of misuse of section 124A IPC and directed all the state governments and also the central government to stay new FIR registrations and pending trials, appeals and proceedings under this section, as prima facie it felt that this section was not in tune with our modern democratic principles. The Supreme Court highlighted the need to balance national security considerations with democratic rights of its people. So now, instead of 124A, we have section 152 in BNS, which says, Act endangering sovereignty, unity and integrity of India. Now, any such act has been declared to be a crime. So, what are the provisions of 152? It says, whoever purposely or knowingly, by words, either spoken or written, or by signs, or by visible representation, or by electronic communication, or by use of financial means or otherwise excites or attempts to excite succession of armed rebellion or subversive activities, or encourages feelings of separatist activities, or endangers sovereignty or unity and integrity of India, or indulges in or commits any such act shall be punished with imprisonment for life or with imprisonment which may extend to 7 years and shall also be liable to fine. So viewers, when we talk about section 152, so what has changed? Let us try and understand this provision. First of all, if we talk about the mental element, the old section was silent about the mental involvement, but here there is a component of mens rea, that is, the accused should have acted with the purpose or with the knowledge, and that is why it uses the terms purposely or knowingly. Then coming to the physical component of this crime. So in this provision, what is the physical act required? First, there should be words, either spoken or written, or it could be by signs, by visible representation, or it could be by electronic communication or by use of financial means. So you see, these two terms, electronic communication and use of financial means, they have been introduced in this provision for the first time, because we have to understand that nowadays people utilize social media, emails, WhatsApp and so many other different kinds of electronic communications to spread information from one place to another. Now when the physical act that is required to constitute the crime under section 152, so now it could have been done either by spoken or written words, it could be done by visible representation by signs, and it could also be done by means of electronic communications or by use of financial means, or in the end it says otherwise. So when we talk about the physical component, the usage of the term otherwise, what does that imply? Now they have made it very, very broad. So if there is anything, if tomorrow there is some new sort of a problem that crops up, some new modes of communication, so what would happen now? This law would not be obsolete and this would be still equipped in dealing with those crimes because of the futuristic vision of our lawmakers, in which they have used terms such as otherwise. So now it could be applied by interpreting it in that in the light of those contemporary needs of those times. So what should be the objective behind the act? As we discuss the physical component of the act, so what should be the objective behind that act in order to constitute a crime under section 152? So the law says, so the act should be done with the objective to excite or attempt to excite some sort of a succession. What is succession? It means some sort of a division, partition, rift, or anything which causes a person to break away from the main group. So the objective should be to excite, to attempt to excite secession or armed rebellion, or it could be some sort of subversive activities, or when somebody encourages feelings of separatist activities or endangers the sovereignty or unity and integrity of India, or indulges in or commits any such act. So you see, whoever encourages public disorder to pose a threat to our sovereignty, unity or integrity of India, now such a person would be punished. See, under the law, even attempts at committing any of these activities, attempting to excite hatred, successionist activities or any of these things, so even attempts are punishable. Attempt could be successful, it could be unsuccessful, but it is an attempt nevertheless. See, why is an attempt not successful? Why does it remain only an attempt and not translate into the crime? That is because there were some supervening circumstances that prohibited this attempt from translating into the forbidden consequences. Had it not been for those supervening circumstances, the attempt would have translated into a crime. And that is the reason why attempt is also to be punished as a crime. So herein, whether it is a successful attempt, even if it is an unsuccessful attempt, the punishment would be provided. And what is the punishment provided under the law? It says imprisonment for life, or with imprisonment which may extend to 7 years and shall also be liable to fine. So what is the difference between section 124A and section 152? So how has this new provision which deals with treason or deshdroh, how has it changed from 124A which dealt with sedition or rajdroh? So 124A of the IPC says, whoever by words either spoken or written, or by signs, or by visible representations or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India. Section 152 doesn't use the term government. So 124 talks about the government that is established by law in India. It says, then the punishment shall be imprisonment for life, or with fine which may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. So in 124, the option was either imprisonment which may be up to 3 years, or it could be fine. So fine could be added to imprisonment, and in some cases it could be only fine. So there was no need for imprisonment necessarily. Now coming to section 152, what it says? Whoever purposely or knowingly, by words either spoken or written, or by signs, or by visible representation, or by electronic communication, or by use of financial means or otherwise, excites or attempts to excite secession or armed rebellion or subversive activities, or encourages feelings of separatist activities, or endangers sovereignty or unity and integrity of India. See, it doesn't talk about government, it talks about the state, that is India, or indulges in or commits any such act shall be punished with imprisonment for life. So this is the same as was given under 124A. Then it says imprisonment which may extend to 7 years. Under 124 the punishment was 3 years, and it shall also be liable to fine. So under 124A there was an option. The accused could be either sentenced to imprisonment for life, or could be sentenced to imprisonment up to 3 years, to which fine could be added, or it could be only fine. Now herein imprisonment has to be there. Imprisonment could be either for life, or it may extend to 7 years. In addition to that, what it says is that the accused shall also be liable to fine. So now it is not imprisonment or fine, it is imprisonment and shall also be liable to fine. So now fine is additional. So while 124A, it dealt with acts against the government, section 152 of the BNS, it deals with actions endangering the sovereignty, unity and integrity of India. Then by inserting the requirement of mental element, that is by inserting the terms that are equivalent of mens rea, such as purposely, knowingly, so now it has raised the bar for prosecution. Thus, those activities that threaten the nation are to be punished, while at the same time, what do we have to protect? Freedom of expression. See, having a balance between the safety, security, integrity of the nation and freedom of speech and expression, it is very vital to maintain this such kind of a balance. This is essential for any democracy to survive. So, after introduction of element of mens rea, now treason, which has replaced sedition, now this is no longer a strict liability offence. So this new provision, it offers a more nuanced approach. by safeguarding the freedom of speech and expression, and on the other hand also protecting the interests of our country. Now this provision, it has also been made more contemporary by introducing the term electronic communication. However, when we talk about electronic communication, there is one matter of concern, and that is Section 20 of the Telecommunications Act of 2023, which permits interception of telecommunication. Now see, the state gets power to inquire. State can seek information on grounds of suspicion, and it can do so even in absence of concrete evidence. So this is a matter of concern because our privacy may be compromised with. So here we need detailed procedures to regulate interception of information and data between two or more private individuals. Then there is also an explanation to section 152. It reads, comments expressing disapprobation of the measures or administrative or other action of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite the activities referred to in this section do not constitute an offence under this section. So now this is an explanation which includes the old explanations 2 and 3 to section 124A, and what it says is that now you have a freedom to express disapproval of the measures or any administrative actions of the government, but this should be done in a bona fide manner. So how do we ascertain the bona fides? That is, if you have taken due care and precaution because you do not want to excite any hatred towards your state. What you want is, you want the state to alter the policies and you want to bring about those changes by lawful measures. See, this is a provision by our people for our people, by our democratically elected representatives. The objective is not to punish or to suppress any kind of a dissent in the state. The objective is that in case we want to bring about any changes, in case we want the state to bring about any changes in its policies, so we have every right to question our state. See, we are questioning our representatives, and in case we are not satisfied by what is being done, we have every right to ask them to change their policies. The only requirement is that we have to bring about those changes by lawful measures without attempting to excite any of the activities that have been mentioned under section 152. If all this is done in a very peaceful, lawful, bona fide manner, then no offence is being constituted herein. See, what does disapprobation mean? It means disapproval. So the amount of disapproval, the amount of disapprobation is immaterial. What is significant here is the intensity of excitement that it can generate against the state. And that is what is to be taken into account while determining the quantum of punishment. See, the amount of disapprobation might be very little, very trivial, but that would be sufficient to arouse feelings of disaffection amongst people. So people might be standing up against their own state, and if that is what the impact of that disapprobation was, then in such cases the quantum of punishment would be more. So there is a lot of discretion now with our courts in awarding punishment depending upon the intensity of excitement that the disapprobation was capable of generating against the state. The term government that has been used in the law. See, now this is something which includes the executive power in action. It does not merely mean the constitutional framework. Now this includes the state government as well as the central government. This was held in 1932. See, this is a very old judgment. K.C. Roy versus Emperor, but it was way back in 1932 when it was clarified that the government would mean the executive power in action also. Then there was this another judgment of Dhirendranath Sen, 1938, Calcutta High Court, in which it was held that a general criticism of certain officers, it cannot be deemed to be a criticism of government established by law. So, viewers, when we talk about the crime of sedition, in regards to which there were certain clarifications which were issued by the courts, because by and large that was a provision which was perceived to be very, very draconian. The impression amongst people was that any kind of dissent was not acceptable and it had to be quelled by the state with an iron hand, because it was a dissent or it was some sort of a disaffection or hatred towards the government. Or now what we have changed is, instead of government we use the term state. So now what has happened is, instead of criminalizing sedition, now what has been criminalized is treason. It is not only Rajdroh. Now what is punishable is Deshdroh. Along with that, the higher punishments have also been prescribed. That is, in case there is any such thing, it has to be curbed with an iron hand. But unnecessary prosecutions, abuse of the process, that needs to be minimized by the new law. Now, in addition to this, there are certain other changes that have also been introduced in the chapter titled Crimes Against State. Now, one of those is section 153 of the Bharatiya Nyaya Sanhita. Now, this is a provision that has replaced the old section 125 of the Indian Penal Code, which said waging war against any Asiatic power in alliance with or at peace with Government of India. Now, these terms, any Asiatic power in alliance with, that has been effaced from the statute, and now the law is under section 153, waging war against government of any foreign state which is at peace with Government of India. So, what the law says now, whoever wages war against the government of any Asiatic power in alliance with foreign state at peace with the Government of India, or attempts to wage such war or abets the waging of such war, so that they shall be punished with imprisonment for life, to which fine may be added, or with imprisonment of either description for a term which may extend to 7 years, to which fine may be added, or with fine. So, you see, even fine may be added to such kind of a punishment. Why is this? Because we as a nation, we are committed to maintaining peaceful and friendly relations, not only with our neighbors, but with the entire international community. So, now we have removed the terms which were giving it a narrow interpretation, that is Asiatic alliance. Now, we are talking about any foreign country which is at peace with India, and anyone who tries to disturb this has to be punished. Then coming to section 154 of the BNS, which has replaced section 126 of the IPC, that was now committing depredation on territories of foreign state at peace with Government of India. So, the law says whoever commits depredation or makes preparations to commit depredation on the territories of any power in alliance. So, this has been now removed. Earlier it was any power in alliance. Now, it says any foreign state at peace with the Government of India shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine and to forfeiture of any property used or intended to be used in committing such depredation or acquired by such depredation. So, what is depredation? Is these are certain acts that cause extreme damage. Now, this extreme damage, it might be caused to human lives or it might cause destruction of properties. So, viewers, in this session we talked about the provisions relating to the chapter offences against the state and how the law has changed from Indian Penal Code 1860 to the Bharatiya Nyaya Sanhita of 2023, which is a more progressive, contemporary and futuristic law. Thank you. Jai Hind.